Good morning, everybody. Let's go ahead and call the meeting to order. Ms. Linker.
Commissioner Cardenas.
Here.
Commissioner Hatch. Commissioner Hatch.
It appears he's muted.
He appears to be way out there.
There he is.
Yeah.
Commissioner Hayward.
Here.
Commissioner Wilson.
Here.
Chair Matich.
Here. Well, good morning, everybody. I have a couple opening remarks. First and foremost, I would like to welcome Galena West to her first commission meeting as our new executive director. You've been a fantastic chief of enforcement for many years, and I know we all look forward to continue to work with you in your new capacity as executive director. So, welcome. Secondly, I wanted to share some unfortunate news, and that is that Commissioner Hayward has informed us that she will be resigning from the commission at the end of the meeting today to pursue a new and very exciting job opportunity. So I wanted to take a moment and to thank Commissioner Hayward for her service to the commission and to our state. Commissioner Hayward is hardworking, she's incredibly smart, and has always demonstrated the highest level of impartiality and integrity as a commissioner. In addition, on a personal note, she's somebody who I consider to be a friend. And so, Commissioner Hayward, I'm sad that you're leaving us early, but I'm excited for you in the new opportunity. So thank you very much. I understand you have a few remarks you'd like to make as well.
Wow, I'm not sure I can follow that. No, I just want to say initially that I wasn't really looking. This was kind of an opportunity that came to me that would not be something I could entertain doing unless I, leapt at it when it was available. Basically, I'm joining the oversight board of Facebook, which is an independent entity, as senior staff to work on the appeals that people bring to the oversight board when they don't like a decision that Facebook has made. And it's an international staff, which presents interesting time zone challenges, but also a great opportunity to do something similar but not identical to what I've been doing ordinarily through my career, which is evaluating speech in contentious situations and trying to apply fair and impartial rules to decisions made about whether or not speech should be allowed to persist in various ways. So having said all that, I have some observations I'd like to make real quick. First of all, I really want to thank all of you, staff and colleagues, for just being a wonderful team. It was, I'm going to be honest, kind of a struggle to get here, but I'm sad to be leaving right now because I think we're a group that by and large is pushing in the same direction pretty consistently. And particular David Bainbridge, I think is a terrific, level-headed, excellent judgment, great general counsel. Galena West, who I know will have a great experience as executive director, was, I think, a fantastic director of enforcement. And I know a lot of my colleagues on the other side of the dais out in the world are very excited that she's going to be executive director and really admired her work as the enforcement division chief. Jay Warega, I'm so happy that we're now being able as commissioners to see those media reports and understand what you do every day. I think you make a very tricky law much more comprehensible to the public, and that's really important. Larissa Hahn, who steps in cheerfully when we need her, and is just a delightful person who I've really enjoyed getting to know. And last but not least, though he's not here anymore, Phil Ung, I really thought did a terrific job for us as our legislative advocate, and was just, again, somebody I really enjoyed getting to know. And my colleagues, I won't single you out. I do want to mention somebody who, again, is not here, who I really enjoyed working with, which is Alice Germain. Remember her? Between writing co-authoring editorials with her and just generally getting to know her as the force to be reckoned with in her political party. That was very gratified to have made that connection. I guess you'll indulge me for a second. I want to talk a little bit about sort of the goals I thought were important and I thought we did well at handling. Continuing, even on this agenda, the misuse of public money by public entities in campaigns, I think is a hugely important place for us to apply our authority. Certainly all we do is the transparency aspect of it, but that's still important. It's just way too easy in this era of bond measures and strapped for cash local government for local governments to fall into this problem. And there are certainly political consultants out there that are happy to advise them on how to do it. And that's just not an appropriate use of public resources. Everyone else has to form a political committee. I think local governments should have to as well, and state governments and special districts and all the other people who are involved. I'm looking forward to increasing LLC transparency. I think what we were able to do under our existing authority will help a lot. I'm also very pleased with as much as we could do on the issue of politicians using political money for sexual harassment matters. Although what we got from the legislature wasn't exactly what we asked for, it certainly was a push in the right direction. And I'm grateful for all the folks who worked on that. And in general, personal use. It's way too tempting when you've got a multitude of committees that as an elected official you can operate to start treating them like your own money. And that comes in forms of not just having committees, but behests. To the extent that we can keep people's feet to the fire so they don't succumb to those temptations, I think that's really important. So challenges that I'm leaving behind. I was really interested in seeing how the new default contribution limits were going to kick in. And I think you guys are going to be on the front lines of some interesting advice requests and problems as that rolls out. People not understanding what they are, how they apply, who they apply to, that kind of stuff. Also, perennial issue is what I perceive to be an overabundance of conflicts. When we look at conflicts, I think sometimes we're too ready to look at the one side, which is, well, you might have a personal conflict here, and gee, it's just asking you to recuse and not vote. Well, on the other hand, some of the folks who were asking not to vote were perhaps candidates that were voted into office for those very issues. And I'm just being mindful that clearly, while we can't change the statute, we can certainly think of the conflicting and balancing interests involved when we're asking somebody who's elected to perform a public function to not do it. So in sum, we work with a very tricky law. It's a law that's different from the laws in other states, certainly different from the feds. It's important to keep enforcement robust and even-handed, but also tempered with a certain amount of humility and empathy for the local people, especially the part-timers and the volunteers who get wrapped into our system. And with that, I'm going to stop talking and we can get to work.
Thank you, Commissioner Hayward. Commissioner Hatch.
Thank you, Mr. Chairman. As a person who was first greeted when he got sworn in the commission, it was Allison Hayward who first contacted me to do the welcome wagon bit. I didn't know her from the Man in the Moon, but I soon fell in love with her. She is just the most amazing person I've ever met. When she tells you something's true, you got to know it's true because she has already checked it out and knows for sure what it is that is in every case that I've come across. You're going to be missed, especially by me. I really, really admire you, and you're going to be really hard to replace. If we can find anybody half as good as you, I would be amazed and very happy. I wish you all the best in your new adventure. But I sure wish you were around for the rest of mine. Thank you, Mr. Chairman.
Thank you, Commissioner Hatch. Any other, Commissioner Cardenas?
Thank you, Mr. Chair. I'd like to move that we bar Commissioner Hayward from ever leaving.
Second, third.
I realize that's not an appropriate motion, but it's the most appropriate sentiment I can think of. Similarly, Allison was the first to extend her hand in friendship to me when I was first appointed, December 2017. She's been a friend, and I've been honored to be her colleague. I've been always struck by her integrity and her fairness, and as Commissioner Hatch pointed out, her unparalleled intelligence and her intellect. I could not agree more, Brother Hatch. When Allison Hayward says that something is the truth, it is the truth, and she knows it to be the truth. And that's an increasingly rare commodity, I'm sorry to say, in my estimation, in public service. I've served in a number of regards in a number of places, different public constituencies. Allison Hayward is among the very finest public servants I've ever served with or I've ever seen. I consider Allison a friend and a lawyer's lawyer, which in my estimation is a compliment. She's a first-class public servant, and the entire state of California owes her a debt for her service and her integrity on this very critical commission. I will miss you very much, Allison. I wish you and your family the very best. And someday I will make good on that bagel that I still owe you. Godspeed to you.
Thank you, Commissioner Cardenas. Commissioner Wilson?
Well, those are two hard acts to follow, but when I joined the commission last December, I immediately recognized the hard work and intelligence of Commissioner Hayward and the value that she brings to the commission. She's indeed a true public servant. She previously worked in the legislatures, worked at the federal level, and she's a real asset to the state of California. And I wish you the best in your new endeavor. Thank you.
Thank you.
All right. Thank you, commissioners. All right, well, we're going to have to proceed at this point to public comment. So public comment for items not on the agenda. Is there any public comment either digitally or by telephone? The one admonition I would just offer at this point is a reminder to everyone that pursuant to our policies, we have a 3-minute limit on public comment, and Ms. Linker will be keeping track of that for us. And I see that we have at least one individual who's going to be making public comment on item 10. Thank you for letting us know ahead of time. Hearing and seeing no additional public comment for items not on the agenda, we will proceed to item number 2, which is approval of our July 2020 commission hearing meeting minutes. Do any commissioners have edits or comments on the meeting minutes? Hearing and seeing none. Do we have any public comment on the meeting minutes? Hearing and seeing none. Do we have a motion to approve?
I move approval of the minutes.
Second.
Motion and a second. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. We'll now proceed to our enforcement consent calendar. That's items 3 through 12. Do any commissioners have any items from the enforcement consent calendar that they wish to pull for separate consideration?
I
Mr.
would
Chair, I'd
ask
like to pull item number 10.
likewise.
All right. So we will separately consider item 10. So at this time, do commissioners have any comments on the other enforcement consent calendar items except for item 10? Hearing and seeing none, do we have any public comment on the enforcement consent calendar except for item 10, which we will be considering separately? Hearing and seeing none, do we have any public comment on the enforcement consent calendar except for item 10, which we will be considering separately? All right, do we have a motion?
So moved.
Second.
All right, Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Excellent. At this time, we'll now consider item number 10. This is in the matter of College of the Canyons Foundation, FPPC number 19-475. Commissioners Hatch and Cardenas requested this item be considered separately. Do either of you wish to make comments on this item?
Do we have a public comment on this particular item? I believe that we do, and if so, I'd like to hear it first.
That's fine with me. Commissioner Hatch, did you have something that you wanted to say before we turn to public comment?
I just think that there are a number of good issues raised. I'd like to hear from enforcement as to their response on the items that he's raised.
All right. Well, why don't we do this? Why don't we let our caller provide his public comment, and then Ms. West and the other commissioners can comment appropriately afterwards. Mr. Petzold, I believe you have public comment.
Yes, are you able to hear me?
Yes, we can.
Okay, very good. Thank you. I appreciate speaking to you today. I wish Ms. Hayward best of luck in her new position. I am concerned about the stipulation that was issued. It echoes and it reflects the same one that was out for July when I brought my concern forward about the organization not being evaluated as a multi-purpose organization. From my standpoint, this is an auxiliary nonprofit organization with close ties to the College of the Canyons, and they made contributions in excess of $150,000 in 1 year. That qualified it as a multi-purpose organization. After that, it becomes, to my way of thinking, important for the enforcement division to evaluate where did those contributions come from, and are they indeed exempt and come from non-donor requirements. I've tried to do a substantial amount of my own research regarding this. I've looked at their Form 990 IRS forms. I looked at their annual audit, and I don't see this contribution reflected accurately in those. When I look at the annual audit, it's almost impossible to decipher exactly where the money comes from. When I made a California Public Records Act request for the Funds for the Future, I was informed that they didn't have such a document because only disbursements come from the Funds for the Future. Now, I don't understand how you make disbursements without making contributions to a fund in which you write checks for $150,000. The individuals that approved this contribution to the Yes on Measure E committee are all employees of the College of the Canyons public agency. Diane Van Hook, President and Chancellor, Charlene Colio, Business Services, and Kathy Ritz, the Chief Operation Officer. So I'm concerned that this wasn't properly evaluated as a multi-purpose organization. I wondered whether that was even considered in this complaint. In regards to the stipulation, I'm surprised that there were no names of anybody that was responsible at the foundation for not filing the campaign filings in a timely manner. So the nonprofit organization, to my way of thinking, is going to end up, paying a fine for the illegal activities of those who should have been responsible for taking care of the filings. At this point, I believe my comments probably reflect my feelings, and I hope that we can get a good explanation from the Enforcement Division.
Thank you very much.
Thank you.
Thank you, Mr. Petzold. Ms. West, would you care to comment?
Good morning, Galena West, Chief of Enforcement. As you all know, this was agendized prior, and then we received Mr. Petzel's inquiries. And so I pulled it from the agenda in order to check into all of those inquiries. And the level of satisfaction that I've found is the same with every enforcement case. This was thoroughly investigated, including looking to see what type of committee that the foundation qualified as, and that was all part of our investigation, which I obviously can't talk about certain parts of the investigation, but I can say what the conclusions were, which the conclusions was this was a major donor committee. The foundation is named as the party, which is our practice. If you look at the two comparable cases that we cite, it's almost identical situations where it's the KCRW Foundation and Burbank Hospitality Association. The board is over 40 members. This is the practice for major donors. They don't have treasurers or principal officers. So if this did qualify as a recipient committee, that's when you would see the naming of the people who are responsible for the actions. So as a major donor committee is separate, it's a different type of entity, we treat them differently, and that's because they are different. And so as treated with every other major donor case, this was consistent in how it was charged. And as I said, the investigation did address where the contributions came from.
Thank you, Ms. West. Do commissioners have questions or comments? Commissioner Hatch?
Ms. West, as I understand it, this committee is actually a quasi-public agency captive of the school. Is that not correct?
Quasi-public agency, I'm not exactly sure of the term. It's a foundation that's associated. We don't consider it a public agency under the definitions of the Act. If you're talking about in layman's terms, I'm not sure.
Okay. Well, if it's created by and governed by the public agency, it is a quasi-public agency. Under that, I just assumed that that's where you perhaps you aren't.
I'm sorry, I can't hear you.
I'm sorry, I trailed off. I said I assumed that you were going there, but if you weren't, pardon my interruption. But it seems to me that they are a public agency, and if so, there are other laws that we have spending, reporting money spent by a public agency. If not, then I'm not sure why Mr. Petzel's point isn't correct in regard to them being a multi-purpose agency.
Certainly, and the multi-purpose test is applied in these situations, but this is in a nonprofit auxiliary organization, and therefore not a public agency under the definition as under the Act with the Siegel test. So if you go with that premise to begin with, then yes, it would be evaluated that way, but we found that premise to be untrue. And so we evaluated as a major donor committee, which is what it qualified as.
I see. Thank you.
Do any other commissioners wish to comment on item 10?
Yes, Mr. Chair, thank you. Ms. West, was this item before us today as agenda item 10 and the prior stipulation involving essentially the same parties that you referred to, which I believe you said we took up in July. These were once upon a time agendized together?
They were agendized close in time, but generally what happens is the committee that is the ballot measure committee that's received the contributions from the major donor committees. As you read that stipulation, there were 15 identified major donors that may not have been proper in their reporting. And so then the cases that spin off from those are generally after the main case, because the main case is proven and then the allegations regarding whether or not the truth of notifications being sent to those committees is then taken into consideration to the later cases, because that's a factor that we look at for whether or not major donors were notified of their obligations.
I see, because I was going to suggest that where we have a transactional nexus, as we do here, where that counts in each of these two stipulations, if I'm not mistaken, and I'm prepared to be, I sometimes am, but I think the transactions in each of these two stipulations are common, which would suggest to me, absent some other material procedural reason for having them being staggered, which you suggest exists here, that they should be agendized and taken up together. But you're suggesting that the the ability to make a full case with respect to I'll use the term ancillary cases is strengthened by being able to establish requisite facts and findings with, shall we say, I don't know if you refer to it as the core case or the main case, but can you just state for me whether or not I understand this correctly, that your position is that establishing the main case first and prior to related cases justifies hearing those related cases at a subsequent board hearing?
That is correct, but in the context of major donors. So if the cases are related in two halves of a transaction where one didn't have the responsibility to notify the other, then those cases we generally try to keep on the same agendas in order that you see both sides of the story. We have many cases that are going through the enforcement process right now that are related enough that they're all assigned to the same attorneys and investigators, and they're treated as a package. And so that's the case when you have, say, 4 different players and 3 committees dealing in a certain scheme that's happening. We try to lump all those together so you get the full story. And if they're denying or blaming each other, then you get to see that at the same time. Whereas with this, you're determining whether or not notifications were made. And so that is one of the core elements that we look at when determining the severity of harm in the later cases.
So the discrete aspect of the transaction that warrants dealing with the foundation subsequent to a finding with respect to the Yes on E committee is the fact that the Yes on E committee had a legal obligation to notify the foundation of the foundation's reporting requirement? Correct. Okay. I'd like to get to the foundation and the foundation's reporting requirement. Which of the counts deals with the? Are there 2 counts that we're being asked to find here?
2 counts, correct.
There were 2 counts, but there were more than 2 non-filings or late filings. Is that not correct?
Yes, there were 3 24-hour contributions, $50,000 each in count 1. And that same activity is on the major donor semi-annual filing for count 2.
Let me just suggest for consideration as a policy matter, if not today, moving forward, that where we're dealing with not a $500 late contribution or $1,000 late contribution, but when we're dealing with a significant contribution, or in this case, a series of contributions of $50,000 each, that may warrant, as a policy matter on this commission's part moving forward, that may warrant assigning a count as to each late filing, not to the category of late filings, which subsumes multiple acts of late filings, knowing, reckless, or inadvertent.
And if the commission gives that direction, I know that's something Commissioner Hatch has also been a proponent of. I would just ask the commission also take into consideration the divergent advice that has been provided to enforcement about the enforcement of major donor cases, which is major donor cases are considered not as egregious as other cases since they are a special type of committee, and generally the reporting is done by the recipient of the contributions, and they don't have knowledge of their obligations under the Act unless they are notified. So those two parts of advice from the commission can sometimes be contradictory, as they are in this case. So I would ask for the clearer direction as to are we including major donor committees in that evaluation for going forward?
And to Ms. West's point, if I may, I think when we're talking about questions of what direction we want to give to enforcement as a policy matter, we are right now, not at this meeting, but we're in the process of reviewing the enforcement process regulations. And to my mind, this may be a good example to bring up in the context of that conversation, but I think direction to the chief of enforcement to enforcement should be in the context of that item when those regulations are presented, so that everybody is clear what the operating rules are. I think you both, Commissioner Hatch and Commissioner Cardenas, you raised good points, and we should take note of those and keep them in mind and come back to them when we're talking about the regs. The second point that I'd like to make, though, more substantively is, Ms. West, is it also true, I understand that there were 3 24-hour contribution reports that weren't timely filed, and they were significant amounts, but those transactions were disclosed to the public before the election through the committee's reports. So this is not a situation, unlike some other situations where we've seen where the voters didn't have this information prior to the election. They did. They just didn't have it in 2 places. They only had it in 1 place. Is that true?
That is correct. And it's also the same information that is being charged in count 2.
Right. Okay. Commissioner Hatch?
Thank you, Mr. Chairman. On that point, we have a inconsistency between streamline, which I think is the correct way to do it, wherein every violation is a count, and mainline, where you bunch these together from time to time and depends upon circumstances. I strongly believe that we should count each count, but if you feel there's mitigating circumstances, then lower the fine per count. At least that way, there's some, harmony between the 2 programs. And I think strongly that the way it's handled in the streamline is the appropriate way to do it. Count them all, but adjust the fine based upon the mitigating circumstances. Thank you.
Thank you, Commissioner Hatch. Commissioner Cardenas, did you have anything?
Mr. Chair, if I might. The suggestion was made that the foundation as a major donor committee may not be, and perhaps we typically tend to presume that a major donor committee may not be as aware of reporting and disclosure requirements as actual campaign committees, such as Yes on E, or even more to the point, committees servicing recurring campaigns, for example, an elected official who stands for re-election. But to me, that just begs the question: are all major donor committees the same? Can we and should we continue to presume that a major donor committee, just as such per se, should have the safe harbor of such a presumption? In the federal law, in corporate securities law, in the area of disclosure and reporting, we make a distinction between smaller mom and pop type investors who are not regular investors, not big fat cats, and so need the benefit of the type of full disclosure that the SEC was created to to ensure, at least by publicly traded companies. A sophisticated investor, however, is somebody who, by virtue of their size and the regularity of their trading activity, really does know the law, or is in a position to be safely presumed to know the law and comply with the law. This particular foundation is not some small neighborhood activist organization that is active in a particular campaign, was never formed before, and is going to go away in a few months. This is a significant organization with, I believe, as was represented today, over 40 directors. I think the actual number may be something along the line of 44 directors. They may not all rise to the level of the corollary of a sophisticated contributor, shall we say, but surely among this significant sized board, a board that raises, if they can give $150,000 to a local campaign, then they've got some resources. And if they've got some resources, it means that they raised resources out in the community. People, I speak with some experience here, people who can raise this kind of money in the community, they have resources, they have smarts, they have sophistication about the world around them. Somebody surely should have known, I suggest must have known, that their foundation and what is essentially their creation, the Yes on E committee, had legal obligations to disclose and report, and they chose not to. And that doesn't sit well with me. I don't think it should with any of us. And I take more than a little bit of umbrage that we do not have a single human being who is named as a defendant or a respondent in this particular case. The public's confidence in our position as a watchdog on their behalf understandably wanes when we allow ourselves to pass judgment naming only a foundation or a corollary in the corporate world, to name a corporation as a defendant and hold not a single executive responsible for malfeasance. That erodes public trust in democratic institutions, and we shouldn't permit it. There are 44 people, apparently, who sit on the board of this foundation. Somebody's got to be named.
Ms. West, could you respond to why there isn't an individual named in this particular case?
Certainly. I completely understand everything Commissioner Cardenas, Commissioner Hatch have brought up. And we applied the same factors that we apply to other cases. So when you're thinking about the criteria and you're talking about what we consider, are these first-time major donors? Yes, they are. Have they, do we find any evidence that it was a deliberate, intentional act? No, we didn't. Was it disclosed by the other side timely before the election? Yes, it was. And these are all of the things that we consider. Was there notice given? No, there wasn't. So these are the criteria that we presented to the commission for these cases. As to the major donor committee, as I stated earlier, if this was found to be a recipient committee, then responsible people would be named, because that's the type of committee that it is. Our practice has been major donor committees are a compilation of contributions made, no other activity. If there's independent expenditures, then that is a different type of committee, and you can be both types of committees. If they gather money, then they're a recipient committee. We're only talking about the type of committees that make contributions to someone else. And when you look at those types of committees, they're not required to have a treasurer or principal officer. And so in order for us to prosecute cases of major donors and name someone that has caused the obligation, so they would have to have fallen under the definition of aiding and abetting or causing the violation under the Act. They would have to have filing requirements under the Act. So I really don't see how we could name others for major donor cases under the law as we have it without very extensive investigations as to who's causing, who's paid, who meets the definitions under 83116 and 116.5. And so these cases are just the entity, and that's all they are, and that's all they can ever be.
Thank you, Ms. West. Commissioner Wilson?
Okay, just for clarification, as a follow-up to Commissioner Cardenas's question, Ms. West, based on our regulations and our guidelines in terms of the FPPC and specific statutory authority, could one of these individuals on this particular commission for this foundation or this particular foundation, could an individual be named, or would that require more investigation? What are the options, for the FPPC?
Thank you. They could be part of the story in the stipulation, but named as a respondent, it would require more. It would require, and I can read you, I happen to have the act with me. I'll read you what the requirement is. Because with a recipient committee, you have people that have roles. And when you have people that have roles, those are the people that are liable for the actions of those committees. So again, if this had fallen under the multipurpose organization rules, or it had been a recipient committee, then we would have that at our fingertips. But liability is found under the Act under 83116.5. And it says, any person who violates any provision of this title, purposely or negligently causes any person to violate the title, or who aids and abets any person in violation of the title, shall be liable under the provisions of this chapter. However, this section shall only apply to persons who have filing or reporting obligations under this title, or who are compensated for services involving the planning, organizing, or directing of any activity regulated or required by this title, and a violation shall not constitute an additional violation. So we would need to do more on these cases to find out if anyone's getting paid, if there's anybody that meets that definition, which is not the easiest definition in the world.
Thank you.
Commissioner Hatch?
Thank you, Mr. Chairman. I had a couple of questions of our esteemed departing Chief of Enforcement. There's a reference in Mr. Petzold's letter to the where'd the money come from and the quote non-donor funds. To that point, I would just ask, the regulations that we adopted on this subject matter earlier this year, had they applied at the time, would there not be more information provided about where the money came from? And I'll give you a minute to think about that. And the second question is, I should have wrote it down. There's no second question.
Okay. Well, then let's clarify your first question. Are you talking about the regulations regarding limited liability companies?
No, I'm speaking a little earlier than that. When we, these public agencies that, or multi-purpose agencies, I guess you'd say, that that make contributions from non-donor funds, and we require under the current regulations to provide more detail than just simply non-donor funds. But I know this case is older than that, so they're not subject to these new requirements. I just wanted to kind of get you to say that had this happened now, there would be more information required to be provided.
Actually, I'm going to say the opposite. Because this committee did not actually use non-donor funds. They used non-donor funds and they didn't qualify as an MPO. Because of that, they don't have the extra disclosure that would be under the reg. So it's a moot point because we don't qualify them as an MPO. Otherwise, they would be a recipient committee.
If that's true, then how come we don't know the source of the funds?
Enforcement knows.
Enforcement knows.
I just
Are
can't
they-
tell you.
Are they from
So-
political contributions?
I'm sorry, what?
Are they from political contributions?
No, they're
sort.
from non-donor funds.
Okay. So you're saying that the requirements on non-donor funds don't apply to them because they're just a major donor. Is that correct?
Right. When LIFO was applied and we investigated the records, we found that it was non-donor funds that was the amount sufficient for the contributions.
Okay. And then I remembered question two. You mentioned earlier that this is their kind of like their first, but I just want clarification on is this their first violation? Have they in the past made contributions, whether they did it right or did it wrong? Or
They've
is
never
this just-
qualified as a major donor before. So
They've
not
never
only
made
have they have no history with us, they also have never qualified as a major donor, never filed as a major donor committee before.
But had they made contributions that would qualify them as a major donor, or we just don't know?
What I was told by the investigator and attorney is that they hadn't qualified as a major donor before. Not that they hadn't filed as a major, that they hadn't qualified.
Hadn't qualified. That's what I'm looking for. Done something that made them qualify. Thank you. No more questions, Mr. Chair.
Commissioner Cardenas?
Are there other cases related to these, this foundation and yes on E?
Yes, we'll be looking at all 15. What we generally do is look at all of them, and if they meet the criteria for a warning letter, those will be open and closed with warning letters.
How many cases did you say?
I think there's 15. 15 committees that are 15 major donor possible people that were not notified by the original committee.
By yes on E?
Right. That's why I say sometimes these take a little while after the initial case.
Well, the chair has suggested that the appropriate course, if I understood him correctly, is to take this up in the process of our review of what is appropriate for this type of a case, and I think that certainly needs to be done. You know, in the corporate law, there are situations where liability can be impugned to a manager or a supervisor or executive for wrongdoings committed underneath that person's chain of command. When a person assumes the responsibility of a chairperson or chancellor or half that big shot, whatever it happens to be in any particular organization, there are a lot of perks and public praise that comes with that, but there's also some risk. And part of the risk that is justifiably assumed by a person who assumes this kind of organizational leadership is that they're going to have to be held responsible, or at least publicly identified as being the person at the helm when someone under their charge did something improper or unlawful. And that ought to be the case here. There ought to be a human being who is named here somewhere, if not as a respondent, then certainly, as Ms. West suggests, perhaps in the story. The stipulation does not sit well with me. I just can't support it. I think there's more here than meets the eye. I don't like it. I think it's wrong.
Thank you, Commissioner Cardenas. Commissioner Wolf.
Okay, kind of a follow-up question, Ms. West. What is the largest fine that could be imposed given this fact pattern? Right now it's at $5,500, but what could be the largest fine that could be imposed by the commission?
Each 24-hour report could be charged individually with a $5,000 maximum, and then the semi-annual could have a $5,000 maximum, which would completely not be in line with any comparable cases, but it could be $20,000.
Okay, thank you.
All right, I have a few questions for Ms. West. Going back to the act, because I think it's important, as upset as we may be with the fact pattern here, and I think it's pretty apparent that the foundation was involved in some type of an effort to funnel money to this committee in a way that wasn't fully transparent. That does appear to be clear enough. Going back to the act, though, if the foundation had an executive director who was paid, could that executive director be held personally liable for the failure, for the violations of the foundation?
Depends if they were paid for. So they would it would have to fall under that definition that I read, where they have to be paid for certain activities.
So if they were paid, among other things, because an executive director, as you know, has many different duties. If part of their duties were identifying areas in which they may want to provide financial support, and that would include making a contribution to this committee. If that was one of their duties and they were being paid for that, would they qualify for personal liability?
Yes, planning, organizing, or directing any activity regulated or required by the title.
As I understand your comments in response to Commissioner Cardenas and Commissioner Hatch and Commissioner Wilson, my understanding is, as you sit here today, we're not aware of any evidence indicating that such a person exists and such activities occurred. Is that correct?
Yeah, we don't. We did not look into that. That is true.
If evidence showing that were to come out subsequent to us approving this stipulation, would we be able to charge that person at that time, given the new facts that we don't currently have?
I mean, if it's would we be able to? Possibly. Would it be bad practice? Probably. As you settle cases, there's a public trust that goes with that you're settling the entirety of the case. And to go back and then recharge more counts or things that you missed or things that new evidence. Now, if something comes out that's false and it was a material fact that we relied upon, that's one thing. But if we just changed our mind because we got more information, I think that's different.
All right. So the foundation, according to the STIP, it's a nonprofit auxiliary organization. Is this the type of nonprofit that's formed under the IRS rules?
I believe so.
And there are also rules under the state of California, I believe, that govern nonprofits?
Yes.
My recollection, and it may be faulty, is that nonprofits have to publicly disclose some of their officers. So do we know, have we checked to see whether those records reveal that they have paid officers?
I believe that we have the forms and they were reviewed, but I don't remember exactly what they say at this moment.
Right. At a minimum, given the flavor, for lack of a better term, of the facts that are apparent here, I think that this may be a case. I know we've done this before, but should we not refer this to the IRS or the appropriate state agency for further evaluation, because there are restrictions on the types of political activity that nonprofits can engage in and still maintain nonprofit status. And so to the extent that there is any risk that those types of rules have been violated, I do think is a matter of serving the public. And I know you've done this before, refer it to other agencies. I'm wondering if this would be an appropriate case to also refer to other agencies.
Certainly, we can make that happen.
Okay. Thank you. Commissioner Wilson?
Yes. One of the concerns that I have, which raises, some of these issues have been raised, you have a 44-member foundation board. They're not doing the work, okay? I mean, if it was 4 or 5 members, maybe they could just say, let's get together, let's discuss the foundation. With 44 members, somebody's organizing the meeting, somebody's drawing up the agenda, somebody's, doing the minutes. So there are more layers to this. And my question, and it's a procedural question, is it feasible to put this item over until one of our subsequent meetings?
That is an option. You would reject the settlement as proposed.
It's not a motion, just a question.
So that triggers a follow-up question in my mind. If we did reject the settlement, would we be able to have enforcement confirm or deny that there are paid officers and that their duties would include making decisions related to contributing to committees, so that we would know with more precision as commissioners whether there is a person who could be charged? And I know there's confidential information. I'm not asking you to divulge this if you can't, but I'm procedurally, if we rejected the STIP, could enforcement do additional work?
I'll defer to the general counsel on the limitations, but from my understanding, the commission can reject the stipulation with direction. It's generally been direction about the penalty and not about specific additional investigation. That would be the part I am unclear on. Any opinion?
And before we put Mr. Bainbridge too much on the spot here, I think, correct me if I'm, and I guess I am putting you back on the spot, because I was going to say what we could do is we could vote to put the STIP over to another meeting while Mr. Bainbridge has an opportunity to advise us on what the possible options for enforcement are, and at that point we would have more direction, right?
Yeah, both of those are options. I can't say I know the answer for sure off the top of my head, so that might be a better path to go.
All right, Commissioner.
He probably has his 90% answer in his head, but.
Commissioner Cardenas.
Mr. Chair, thank you. Ms. West, to the extent that you can state, are any of the 15 other, are there 15 other cases or 15 other parties, or both?
I don't know if they've been opened into cases as of yet, all of them. So you can just call them parties. You can call them possible respondents.
Right. The other parties, the other possible respondents, it was suggested there may be as many as 15. Do we know if any of them are, this is a rather broad and nebulous term, related to the foundation by virtue of interlocking directorates or by any other means? What I'm getting at is basically a coordinated effort to fund, funnel, and non-disclose.
That's public information on the recipient committee's statements, and I did review those before this meeting, and nothing jumped out at me, because I like to know what percentage these contributions are to the committee. Like, was it, because when things strike you, you want to know, was it sponsored, was it not? And the committee received a lot more money, and so I think I might have that stipulation with me just for fun. Oh, I tried to lick my finger. Yes, I do. Okay, so I can kind of go over San Clarita Community College District gave $50,000. NE Systems gave $10,000. Lundgren Management Corp., RC Becker and Son, IPBWS Architects, Subsurface Designs, Westfield Valencia Town Center. So it seemed quite varied to me when I reviewed it. So it did not raise any red flags for me. It's in the stipulation for case 17287. We publicized all of the donors.
Aren't some of those donors business with the, excuse me.
Go ahead, Commissioner Hatch.
Some of those donors you read off look like they're people who do business with the college. And it's kind of all happens at the same time. Sounds like somebody's working really hard to raise this money.
Yes, the Yes Committee raised the money.
And I'm feeling like this doesn't doesn't feel very good. I tend to agree with a lot of what Mr. Cardenas has raised. And I would certainly like to see this put over with direction to dig a little deeper on these issues that he's raised.
All right, well, commissioners, I want to draw your attention to the fact that we've received a number of digital comments from Mr. Petzold, which I know you can all access, but also we have a request for additional public comment from Lacey Keys. She is counsel for the respondent. So unless there's an objection, I'd ask that we permit Ms. Keys to provide her public comment at this time. All right, Ms. Linker. Can you hear us, Ms. Keys?
I can. Can you hear me?
You're a little faint. If you could turn up your mic a little bit. Let's see.
Is that better?
That's much better. Thank you.
Great. Thank you, Chair Matich and Commissioners, for the opportunity to speak. The comment I had intended to make was a little bit further in the past regarding, in particular, the nature of the foundation as an organization. Auxiliary organizations are permitted under state law, and it sounds like there may be some question as to whether we're talking about a public fund situation that might be coloring the thinking on this stipulation. So I just wanted to kind of dispel some of the potential concerns here about the fact that the entity is considered private. It is a charitable organization for purposes of tax law. And there is an Attorney General opinion directly on point regarding the permissibility of these types of auxiliary organizations participating in ballot measure campaigns when they use private funds. So to the extent there may be an open question about whether or not this is a permissible use of foundation funds, it's clear as a matter of law that this is permissible. The other thing I kind of wanted to point out here is that, that relies on the use of private funds, not public funds. And then the analysis that Ms. West spoke to regarding the type of filings that are required also relate to, use of non-donor funds. So, I wanted to clarify that the foundation has fully participated, provided requested information by the Enforcement Division so that they could analyze the source of those funds to come to the determination that the reports we filed as a major donor identifying the source of non-donor funds were accurate. So I just wanted to kind of clarify that and also, speak to the comments regarding the flavor of the facts. I would just want to make sure that we're not making assumptions regarding intent as a result of the amount of the funds spent. The foundation, as has been stated, is a sponsor of the Measure E committee, and they hired a CPA to assist them with these requirements. The CPA that provided reporting services was not aware of the major donor notice requirements, as is obvious since those were not sent. And the foundation itself was not aware of their requirement to file reports. As soon as that came to light, we got them on file immediately. And I just would point out that, there's not a scheme to funnel funds from some other source. The foundation has been very straightforward about the source of funds that were used. The name of that fund is disclosed on the report they filed in connection with this particular action. And as I stated, they have, voluntarily provided all information and answered the questions that the Enforcement Division has made of them. So I see that my time is up, but I just wanted to kind of provide that additional color here as you're thinking through this particular stipulation, and urge the Commission to move forward if that's a possibility here.
Thank you, Ms. Keys. All right, Commissioners, do we have additional comments at this time? Hearing and seeing none. Do we have any additional public comment on the telephone from folks who have not yet spoken on this item? Hearing and seeing none, do we have a motion?
Mr. Chair, if I might, it's not a motion, but it's a belated opportunity to respond to your invitation for further Commission comments. If we can just request that our staff procure a copy of the referenced Attorney General opinion.
I'm sure Mr. Bainbridge can acquire that for us and distribute it to the commissioners, if you wouldn't mind. Thank you. All right, do we have a motion?
I move that we put this over at least, I would say, 2 meetings so that we can filter through the issues that were raised here by Mr. Cardenas and others. And I better shut up. That's my motion.
Commissioner Wilson?
A second.
Before we vote on the motion is to put it over for 2 meetings. I think Commissioner Hatch, you said so that we can sort out some of the issues that we've talked about today. I want to make sure the record's clear on what issues we're asking staff to sort out for us. So I will open it up. What issues, in fairness to our staff, are we asking staff to evaluate and advise us on before we consider this?
Mr. Cardenas?
Well, it was suggested that individual natural persons cannot be named as respondents in the absence of a finding of aiding and abetting. But I wonder if there's a distinction between a finding of actively, knowingly aiding and abetting, and just passively aiding and abetting somebody who is simply under their charge. It's as I heard the recitation of the relevant provision of the act, it was not prima facie clear to me that the act by its terms precludes, in this particular instance, the naming of a natural person.
All right, Ms. West, do you understand that? So that's the first issue. Do commissioners have other issues that they wish to have staff evaluate before we consider this stipulation? Well, if no one else does, I would ask that we receive some type of information, if possible, and tell me if this isn't appropriate, please, Ms. West, that I would like to know as a matter of fact whether or not there is a paid individual whose duties include making decisions with respect to making contributions on behalf of the foundation, and secondly, whether we have any facts to indicate that that individual should be held personally liable for the violations here. So far we have a question of law from Commissioner Cardenas, and I'm requesting more of a factual report back.
Mr. Chairman, question on my motion. Earlier, Ms. West said that there were certain things that were inquired about on commissioners that she was not allowed to give us because it's private. And my question is, can we hear this in an executive session to ask those questions and maybe get some of those answers?
I'm gonna have to defer to Ms. West or Mr. Bainbridge.
So the investigations are confidential, and they remain confidential even after the case is closed. Like, for instance, information that was subpoenaed. What I can offer, since we will be representing this item, maybe we can add some more detail to the stipulation if it's agreed upon by the other side, which as Lacey Keys has said, they have been very cooperative. So we can put some more information that's agreed on into the settlement document to share with the commission.
That would be helpful. Thank you, Mr. Chairman.
Commissioner Wilson?
Yes, technical question on Commissioner Hatch's motion. If we're going to put this over for 2 meetings, we're going to put it over till, just for clarification, until the October meeting?
That's my understanding, is we would put this over until the October meeting. Prior to our consideration of the stipulation, we would receive a report back from staff on the items that commissioners have requested questions
Over-
on, or if they are going to be addressed in the stipulation, then
Okay.
certainly my expectation would be a presentation pointed that out to us so that our questions have been properly addressed.
Okay, yes. I think as an enforcement item, it would be presented as a stipulation for approval with discussion and highlighting of the changes that were made.
All right. So we have a motion.
We do have a motion.
We have a motion. Do we have a second?
Second.
All right. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you, everyone. At this point, the next item is item 13. I would ask the commissioners, we've been going for a little over an hour now. Would folks like to take a break for a few minutes, or should we continue forward? 5-minute break. So we'll re-adjourn at about 11:15. All right, we're going to go ahead and go back on the record. We have come to item 13 on our agenda. And as an initial remark, this is something that's very important to me, this issue of how our agency participates in cracking down, for lack of a better term, on the misuse of public funds and what our role in that is. And unfortunately, though, the County of Los Angeles was a client of mine when I was in private practice, and out of an abundance of caution, even though I have no knowledge of this matter, no financial interest with the firm for over a year, I've consistently recused myself from closed sessions involving this item, and consistent with that, I'm going to recuse myself from voting on item 13. And I would ask Commissioner Hayward, as the vice chair, to go ahead and lead the discussion for this item, and I'm going to leave the room. Thank you, Commissioner Hayward.
Thank you. It'll be interesting to see how this works. Yeah, I guess, who's presenting?
That would be me, Galena
All right.
West.
Okay, well, Ms. West, why don't you just go ahead and give us, refresh our memory on the context, and then and what actually is before us today.
Certainly. Galena West, Chief of Enforcement. It's been so long since I talked. I know you're all missing my voice. The proposed settlement stems from complaint that the FEPC received involving the March 2017 special election in Los Angeles County regarding Measure H, and an additional complaint alleging the county used public funds to support Measure W in the 2018 November election. The FEPC Enforcement Division opened 2 cases alleging the county's activities qualified as a committee, triggering the Political Reforms Act's filing and disclosure requirements and advertising disclosures. In December 6, 2016, the LA Board of Supervisors held a meeting where they unanimously voted for resolutions declaring the homeless crisis an emergency and calling and giving notice for a special election. They wanted to enact a countywide sales tax measure that would increase the county sales tax for a period of 10 years to generate revenue to combat the homeless crisis throughout the county. They called it the Homeless Initiative Plan. The resulting ballot measure was Measure H, and it called for a county sales tax increase of 0.25%. In 2016, the board decided to fund the Homeless Initiative through a proposed sales tax increase that was contained in Measure H. And they allocated $50,000 of the county's budget for a communications plan and advertising strategy. TBWB Strategies, a company that specializes in conducting campaigns designed to pass local ballot measures, was hired to execute the advertising campaign and polling. TBWB's budget was eventually doubled to $1 million. TBWB arranged for television commercials to run on cable news stations touting the work of the Homeless Initiative. The commercials ran on cable news stations beginning February 14, 2017. The advertisements included the words, "The Los Angeles County Homeless Initiative," with the Homeless Initiative logo, as well as the slogan, "Real Help, Lasting Change." The television commercials that ran before the election also included the words, "Measure H on the March 7th ballot. Are you ready? Vote March 7th." In addition to running on cable television, the advertisements ran as digital online advertisements. In addition to the videos, the county also paid for online banner advertisements, radio advertisements to run on Spanish language radio stations, and various written materials. Measure H required 2/3 voter approval to pass. It received 69.34% of the vote, passing by approximately 2.68%. Measure H is projected to produce $3.55 billion in tax revenues over its 10 years. Measure W also passed with 69.45% of the vote after a $1 million campaign in support of Measure H. Our rules let the public weigh the information they're receiving by knowing its source. This levels the playing field for all the players. We believe that this is an important stipulation and we urge its adoption.
All right. Now, it's Commissioner Wilson, I believe, who requested that this be pulled from consent. Would you like to move the conversation forward for us?
Yes. I mean, the main reason that I wanted to pull this from consent is I thought that it was important for there to be a public discussion and not have this just as a quote-unquote non-controversial consent matter. Ms. West, it's my understanding that both sides have agreed to this stipulation. So that was the main point that I wanted to focus on, is that it would at least have some discussion and the opportunity for commissioners or the public to weigh in. But after talking with Ms. West, and it's clear that both sides are in agreement, with the stipulation, that was the main point I wanted to emphasize.
All right, thank you. Now, I obviously can't tell okay, I see Commissioner Hatch's hand. Commissioner Hatch, can you go ahead, please?
Thank you, Mr. Chairman. I just wanted to point out on the stipulation on page 2, beginning on line 6, sort of a heretofore somewhat unique provision that says that the settlement shall not be considered an admission of liability by defendant in connection with this matter, blah, blah, blah. Does that mean that we may have them back before us in future ballot measures if they don't think they did anything wrong?
This case only deals with the two matters that are before you. So any future conduct that we disagree and think that is a campaign-related activity, we will enforce the same way as we enforce all of them. And I think the weirdness of that is in reference to the pending litigation. And as that litigation concludes and we have clear answers for moving forward, I think that will help in the future for even more enforcement matters.
Well, I think this is an important first step, and I congratulate you on a good job, an amazing job actually, to get them to the table. But so it seems like if they don't believe they did anything wrong, they're probably going to do it again, huh?
Hey, any other comments from commissioners? I don't see any hands. I don't hear anybody. Can somebody there tell me if we have any electronic or phone? Oh, Mr. Wilson, Commissioner Wilson?
Yes. Thank you, Vice Chair Hayward. Ms. West, I have kind of one, question. You and I discussed this, but if you could briefly kind of cover what the issues are in the pending litigation involving, these same parties.
I don't know if I should defer to the legal counsel since they are handling that case.
Well, as executive director, that's your call.
I think that I will punt to Dave on this one so I don't misspeak at all regarding the pending litigation.
This is Dave Bainbridge, General Counsel. Obviously, it is pending litigation, so I won't get into it in great detail. I would just, in general, the case involves the California State Association of Counties has challenged the validity of the regulations 18420.1, which the current LA County case is a couple of the counts are based on, and then also another regulation concerning mass mailers sent by public agencies concerning campaign activity, which is, I don't think, implicated in this case, if I remember correctly. So it is a challenge through a writ process to those two regulations and their validity.
And Commissioner Hayward, just one clarification. Some of the questions that I've posed, I found by doing searches on the internet. And I just want to emphasize that Mr. Bainbridge and the staff did an excellent job in terms of maintaining, any confidential information. And most of the information I was able to access was just readily available on a basic Google search. So thank you, Mr. Bainbridge.
Thank you, Commissioner Wilson. Now, I don't see any commissioners seeking to be recognized. So could somebody there in the room tell me if we have any commenters either on the telephone or digitally?
Commissioner Hayward, there is no digital comment, and I have unmuted the phone lines.
All right. I don't hear anybody on the phone. Okay, I'm going to declare that there's nobody on the phone. Hopefully I haven't abridged somebody's rights in a very awkward manner, but all right then, are we ready to call the question? Is there anything anyone else wants to say? Okay, can I have a motion then?
Move adoption.
Second.
Second? All right. Sasha, could you please call the roll?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Commissioner Wilson?
Aye.
The motion passes.
Right then, thank you, everyone. Can somebody go get the chair?
Dave's doing it.
All right, excellent. Chair retrieval service.
All right. Thank you very much, Commissioner Hayward, for serving in my stead.
Welcome.
All right. So we'll go ahead and move on to item 14 then. This is a assignment of hearing to administrative law judge in the matter of Gabriel Dolphin, FPPC number 18/1423. Ms. West?
Oh, I forgot video. So the Enforcement Division is asking that this case proceed to hearing with the administrative law judge. At this time, no vote is required if the commission agrees with that recommendation.
Thank you, Ms. West. Do any commissioners have questions or comments on item 14? Hearing none, do we have any public comment on item 14? Hearing and seeing none, the matter will be referred to an ALJ then. Thank you, Ms. West. Now move to item 15. This is fiscal year 2020-2021 budget update. We have Chief of Administration, Han, with us.
Good afternoon, Commissioner. This is Larissa Hahn. I would like to present to you the updated appropriation for fiscal year 2021 that affected on July 1st of 2020. This is just an update for Commissioner, and the allocation is consistent to our governor's budget back in January. So I am happy to answer any question that you may have.
Thank you, Ms. Hahn. Commissioner Hatch?
Thank you, Ms. Hahn. I noted that you had some approved, they call them budget change proposals that have helped in this budget. Were there any that were sought and not approved for that budget year?
No, we submitted one budget change proposal and it was approved, and it's indicated in one line item, AB 571, for implementation of the new law.
Okay, so there were none that were requested that were turned down.
Correct.
Okay, thank you.
Do we have additional commissioner questions or comments on item 15? Hearing and seeing none, do we have any public comment on item 15? Hearing and seeing none, thank you, Ms. Hahn. Now proceed to item 16. This is our legislative update, and we have Mr. Wairenga or Mr. Bainbridge, whoever wishes to present.
This is Dave Bainbridge, General Counsel. I think Jay doesn't want to get out of his seat, so I'll do it since there's not much to say. The one bill that is still active is AB 2151. It is going to the Senate floor, I believe, today, right, Jay, to be voted on. So that would be the second house, and then it would go to the governor for approval. And that is the ledge report.
Thank you very much, Mr. Bainbridge. Do commissioners have any questions on our legislative report? Hearing none, do we have any public comment on the legislative report, item 16? Hearing and seeing none, we'll now proceed to item 17. These are advisory committee updates. The first advisory committee update is for the Law and Policy Committee. We held our meeting on August 7th, and we considered and received input and an update from staff on their research with respect to behested payments and a schedule of anticipated feedback and report back from them on their work on behested payments. We received interested person feedback on the pre-noticed amendments to the regulations governing the enforcement process. And ahead of that, Mr. Bainbridge and his staff had prepared for us some amendments based on feedback they had already received. And so Commissioner Hayward and I had the opportunity to review those new amendments, which I think in general were a positive change from the initially proposed amendments. In addition to those amendments, we had a discussion about whether we would add to those regulations a requirement that there be a privilege log maintained by folks who receive our administrative subpoenas. I know those subpoenas, if somebody is not going to turn over documents, they're requested to keep the documents safe and have the identifying information available, which is pretty much what you put in a privilege log and the basis for why you're withholding it. And so what we talked about was incorporating into the regulation a bilateral privilege log requirement. So to the extent that our staff, through the quote discovery process, the exchange of documents with respondents, if we are withholding documents because of privilege, we would provide a privilege log to the third parties, and likewise, folks who we subpoena would maintain and produce a privilege log. And I think this is something that may help us resolve discovery disputes in a more timely fashion. So we've asked staff to prepare at least draft language for the Commission's consideration. And all of these changes obviously will come back to the Commission in the future. So this was just an opportunity for us to see where staff is at and give our perspective on that. Commissioner Hayward, did you have anything to add on the enforcement process regs?
No, just that generally the minutes to our meeting are an agenda document on this agenda. So if people missed something or want to go back, they can access those there.
Correct. All right. In addition to that, we also heard from staff who prepared Commissioner Hayward's request. It was one of her many excellent ideas and will be missed after you resign, a committee naming fact sheet. And so we received an update from staff on those efforts, and my understanding is that fact sheet is now up and available. So certainly appreciate them doing that for us. Commissioner Hayward and I considered and discussed some advisory committee procedures. These are internal procedures to help us clarify for staff primarily what our process is for preparing the agendas for the advisory committee meetings, timing, et cetera. I think in fairness to our staff, we weren't always consistent across the board with our advisory committees, and my hope is that this will help bring greater uniformity and predictability to our advisory committees. And so those are separately agendized for our approval today, but the minutes reflect that Commissioner Hayward and I are recommending approval of those procedures later today. And Finally, we discussed the next agenda, and so we would continue to receive at our next LMP meeting, we would continue to receive an update on behested payment activity and continue receiving interested person feedback on both the enforcement process and the streamline regulations. So did quite a bit in LMP. Budget and staffing, we received budgetary information from Ms. Hahn and had a closed session on a personnel matter. And then finally, for our public outreach and technology committee meeting, Commissioner Wilson and I heard a number of informational items from staff. The first was related to our educational program services and resources. So essentially telling us what we're currently doing and discussing various opportunities to improve those efforts. Commissioner Wilson, I think, had an excellent idea that in talking with staff that we asked staff to develop a landing page on our website that's really directed towards folks who may not be familiar with our requirements, and in one place they can find all the training materials that may be of use to them. So Commissioner Wilson and I are recommending that the full commission agree to have staff work on the website to create such a landing page. So unless there is an objection to that, we'd like staff to work on that. We also heard two items related to technology. The first was something, again, that Commissioner Wilson brought up. It was an excellent point involving document security on our website. We have a number of Word documents that you can currently find through our search terms, and even the PDF documents that we have on our website aren't as protected as they could be. And so we heard from our Chief Information Officer, Mr. Crabtree, about the different options we have. And the bottom line is that we can acquire software that our staff can use that would improve the security of both the enforcement documents that we have available on our website, as well as the stipulations that we approve. And the purpose would be to create greater security so people can't tamper those and then present them in a tampered form to the public. And so, Commissioner Wilson, I don't know if you wanted to add.
Yeah, I just want to add that Chair Matich, you covered all the key points, but I want to recognize the staff, especially Ms. Hahn and Mr. Crabtree, for the countless hours that staff put in to compile the spreadsheets and the charts and all the information. I know Ms. Linker was also involved, and probably missing somebody, but it was clear that quite a bit of hours were put in to compile what is very useful information. So thank you.
Thank you. And for clarity's sake, Ms. Hahn, the bottom line dollar figure to acquire the software we need was what?
It was close to $1,200 for 6 licenses.
Okay. So, and I think Commissioner Wilson and I were in agreement that we would recommend that to all of you. So unless any of the commissioners object to that, I personally think it's something that we need to do to ensure the integrity of the documents we provide to the public. So hearing no objection to that recommendation is then accepted. And finally, we had a really interesting presentation, again, from Mr. Crabtree. We asked them to provide us with some website tracking metrics. So our staff was able to go in and ascertain what pages are accessed most frequently, what times of year, and I think they went back to 2016. So we had 2016, 2018, and 2020 year to date. And it was interesting information. I think all the commissioners I think we can send that to all the commissioners so you guys can see that. But the bottom line there is, we hadn't been doing that on a regular basis before. We have the capability to do it, and it is a one-time cost of $400 to acquire the software that will allow us to automate that process so that Mr. Crabtree doesn't have to sit in his office and manually download and arrange those reports, with the Commission's indulgence, Commissioner Wilson and I are recommending that we spend the $400 to acquire the software so that we can continue tracking these things. And in addition to the software, we talked about how we need to make those metrics available within our agency to the various units. I think at a minimum, the public outreach unit, the education unit, should see that so they know which pages are being accessed most frequently, where they can be of greatest assistance to folks. And also, obviously, the commissioners would, I think, benefit from that information. So, Commissioner Wilson? All right. All right, and that concludes our updates on what we did at our last committee meetings. There are two other items with respect to the committees that we need to address today in light of Commissioner Hayward's, I'm going to say it again, unfortunate departure from our commission. When Commissioner Hayward leaves, it leaves a vacancy on law and policy. And I think as it was reflected in the meeting minutes and what we just discussed by way of update, that committee has a lot of activity right now. So I would move that Commissioner Cardenas join me on the Law and Policy Committee. The consequence of that, however, is that under our rules, commissioners can't serve on more than one committee. And so Commissioner Cardenas would then come off of the Budget and Staffing Committee, which would leave a vacancy on Budget and Staffing. And Commissioner Hatch, since you currently are on the Litigation Subcommittee and we don't have any pending litigation matters that require immediate attention, my hope was that you would then agree to come on to Budget and Staffing with me. So the motion would be that Commissioner Cardenas is moved from Budget and Staffing to Law and Policy. Commissioner Hatch is moved from Litigation to Budget and Staffing. So I put that out there for Commissioner consideration. Questions or comments from commissioners? All right, well, that is my motion then. Do we have a second?
Second.
All right, Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Aye. Have fun, guys.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
All right, thank you, everyone. All right, we'll now proceed to item 18. These are the advisory committee procedures. I referenced a moment ago that Commissioner Hayward and I are recommending that the full commission adopt, primarily to create some consistency and uniformity in how we're doing our advisory committees. So do commissioners have questions, comments? Commissioner Hatch?
Yes, I do. I found myself getting a bit confused here and there over the use of chair. In some contexts, it seems like they're talking about the committee chair. Other contexts, it seems obviously that they're talking about the chair, yourself being potentially both. Nonetheless, it would be helpful if where you mean committee chair in that role, you put the word committee in front of chair. It's to highlight my point. In item 4 in the rules proposed, it makes a reference to chair where it seems like you're talking about in the role of committee chair. And I may be wrong, but like I say, it's a little confusing. So I'd like to make that friendly suggestion that you go through it and insert committee in front of chair where you think it's clear that you want to make it clear that that's the role you're talking about.
All right, thank you. And with respect to item 4, that is intended to be the commission chair, solely because the commission chair being full-time is sort of I consider it sort of like the hub of everything. So it's easy for the commission chair to discuss with the other committee members, the other commissioners who are on the committees, and then liaise with staff to make sure that the agenda is prepared properly.
Mm-hmm. Okay, well, to the extent that any of those are supposed to be committee chair, I'd appreciate it if you make that tweak.
Okay, absolutely. Do other commissioners have any questions or comments? All right. Do we have any public comment on item 18? Hearing and seeing none. Do we have a motion to approve?
I move.
So moved.
All right, moved by Commissioner Hatch, seconded by Commissioner Wilson. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Excellent. Thank you, everyone. All right, we'll now proceed to item number 19. These are our executive staff reports. We'll go ahead and begin with our Enforcement Division, Chief of Enforcement West.
The report is as submitted.
Do commissioners have any questions or comments for Ms. West in her capacity as Chief of Enforcement? All right. Do we have any public comment on the Enforcement Division report? Hearing and seeing none. Thank you, Ms. West. Mr. Bainbridge, the Legal Division Executive Report.
As submitted as well.
Right. Any questions from commissioners for Mr. Bainbridge?
Just more of a comment. I'm just thrilled that I'm getting those advice letters early. It's been a very constructive change. Thank you very much for coming up with it.
Good job, Mr. Bainbridge.
Mr. Lau and I are thrilled by it as well. So I'm glad it's working out for everybody.
All right. Is there any public comment on the Legal Division staff report? Hearing and seeing none, we'll move to our Administration and Technology Division report. Ms. Hahn, Chief of Administration.
As submitted.
All right. Any questions for Ms. Hahn? Hearing and seeing none, any public comment on the Administration and Technology report? Hearing and seeing none. Last but not least, Ms. West, welcome back as the Executive Director for your Executive Director update.
So the couple days that I've been Executive Director, I would just report that everybody has been very welcoming. So I really appreciate that. And I didn't need to be shown where the break room was.
Yeah, that's great. That's fantastic. All right. Thank you, Ms. West. Do any commissioners have questions or comments for Ms. West in her capacity as Executive Director? Hearing and seeing none. Any public comment on the Executive Director update? Hearing and seeing none. We will now move to item 20. Do we have any commissioner comments on proposed future agenda items? Commissioner Cardenas.
Thank you, Mr. Chair. I just want to commend Commissioner Hatch on the occasion of our colleague Allison's departure for providing us today, by virtue of his appearance and background, with a stunning impersonation of Charlton Heston in the 10 Commandments.
May I, Mr. Chair?
Excellent.
Thank you, Commissioner Cardenas.
As a defense, I wasn't trying to play Moses. This is actually a picture from the window of my condominium in Long Beach. One of my favorites. We get a lot of beautiful sunsets here, but this one I thought worked pretty good. This is my first attempt to try and make this green screen thing work. I actually have a sort of faded green sheet hanging behind me, but you can't see it, thankfully. Every once in a while you do. And if I would add an unrelated subject, that 80 years ago next week, this old prairie dog from Canada is going to celebrate his 80th birthday. So anyone want to say anything good about that? You're welcome.
Well, happy early birthday, Commissioner Hatch. That's that.
Happy birthday.
Yes.
Yeah.
All right.
Still on top of the grass.
All right. All right. If there's nothing further on item 20, then Commissioner Hayward, would you care to make the motion to adjourn today?
I guess I'm gonna miss you guys. Oh my God. I move adjournment.
All right. Thank you, Commissioner Hayward. Second. All right. Ms. Linker.
Commissioner Cardenas?
Godspeed, Allison. Yes.
Commissioner Hatch?
Love you, Allison. Aye.
Commissioner Hayward?
Likewise, aye.
Commissioner Wilson,
Aye. Thank you, Commissioner Hayward.
Chair Matich.
Thank you, Commissioner Hayward. You are going to be missed greatly. Aye.
The motion passes.
All right. Thank you, everyone. Have a great week. And
Aye.
bye.